of the customer service meetings for 2025. In today's presentation, we're going to talk about the IUC's regulatory oversight, delinquency, the light heat program, the intake process for complaints for IUC staff, legislative updates, agency updates. My name is Marie Jean Blanc. I'm the customer service manager here at the IUC. And with me today is
Stephen Hocklesvik. I'm an attorney with the IUC.
Keita Horace, a utility analyst with the IUC.
And this presentation is designed for community action agencies and utilities in Iowa. Now, the IUC is a regulatory body, but we can't forget about the Office of the Consumer Advocate. They are located at our office here in Des Moines, but they are a division of the Iowa Department of Justice. They receive and review all IUC filings and complaints, and they represent the overall interest of the consumer. For individual complaints, a consumer could contact IUC staff here at the Customer Service Department. They have staff designed to review and file responses on many of the issues before the commission. And so I'm going to turn it over to Stephen to talk about our regulatory oversight and Iowa One Call.
Thanks, Marie. The Commission's authority is delegated to us by the Iowa legislature and comes from the Iowa Code. The Commission's specific code chapters are Iowa Code chapters 474 and 476 through 479B. Additionally, the Commission creates its own rules with input from the public through rulemakings. The chapters that are most applicable to customer service are 199, Iowa Administrative Code chapters 6, 19, 20, 21, 22, and 27. Each utility also has unique tariffs and policies which guide its business practices. Tariffs, which are primarily applicable to investor-owned utilities, are filed and approved by the Commission. Although municipals and rural electric cooperatives do not file tariffs, they do still have policies established by their governing bodies. Although these policies are not filed with the Commission, when a complaint is applicable to a municipal or REC, we may reference their policies in order to help resolve the complaint. The Commission has multiple levels of authority over different industries based on industry type and the company's classification. The Commission has the most authority over investor-owned utilities, where we regulate rates, charges, services, customer service, and general operations of the company. The electric IOUs in Iowa include IPL, which is Alliant Energy, and Mid-American Energy. The gas IOUs in Iowa include IPL, Mid-American Energy, Black Hills Energy, and Liberty Utilities. For municipal utilities and RECs, the Commission has more limited authority, which also impacts areas we can address in complaints. The primary areas we address in complaints for municipals and RECs include disconnections, payment agreements, and safety issues. There is only one investor-owned water utility in the state for which the Commission has jurisdiction. Specifically, the Commission only has rate-regulated water IOUs with more than 2,000 customers, which in Iowa only applies to Iowa American Water Company. The Commission also has authority to regulate Iowa American Water's sewer and wastewater services. However, the Commission does not regulate small or municipally or cooperatively owned waterworks. For telecommunications services, this area is largely deregulated, but the Commission has retained authority over certain areas, which includes the authority to hear complaints. Primarily, we regulate two-way landline communications. We also address complaints over unauthorized changes in telecommunications services, and the Commission has complete rate regulation authority over alternative operator services, which primarily includes incarcerated persons in prisons and jails. We will discuss telecom more later on in this presentation. Some areas the Commission does not regulate include municipal water utilities, municipal rates and charges. We also generally do not assess damages. We do not regulate wireless telecommunications services or the internet, as well as television services. The Commission also partners with the Attorney General's office to investigate one-call complaints. If you have seen the billboards on the interstate that say, "Call before you dig," that is Iowa One Call. The Iowa One Call law requires excavators to report the location of our dig site prior to excavation so that utilities can mark the location of their facilities. Although enforcement authority over one-call incidents is vested in the Attorney General's office, the Commission provides assistance to the Attorney General's office by hearing and investigating complaints. Some common complaints that we see include locate issues, 48-hour violations, 48-hour violations, failure by the excavator to notify the utility of damages, and failure to determine the location of facilities. If someone would like to submit a one-call complaint, you can refer them to any of these locations: the Attorney General's website, the Commission's website, or the Commission's duty officers. So remember, call before you dig.
Okay, we're going to talk a little bit about delinquency and disconnection. And in order to do that, we need to talk about the bill cycle. So on day 1, you issue your bill and it's due day 20. On day 21, you can issue a delinquent notice. It's a 12-day notice with a disconnection date listed. And 12 days after the notice, disconnection can happen if no payment or payment agreement has been made. Of course, there's some caveats and we'll talk through those. Thinking about that cycle, there's the minimum of 21 days before the bill becomes delinquent. The utility can then charge a penalty. You cannot charge more than 1.5% per month of that past due amount, and you cannot assess a collection fee in addition to the charge. A customer gets at least one forgiveness of a late payment charge each calendar year. Year-round, all utilities need to make a diligent attempt to contact the customer by phone or in person. And November 1st through April 1st, a door post is required prior to disconnection. Sometimes a customer will enter into a payment agreement through that delinquency process. And if they default on that payment agreement, the utility can disconnect with 24-hour notice. Another aspect of delinquency is what's called the customer rights and responsibilities. This is part of the Iowa Code, and it should be provided with all disconnection notices. Please note that the customer rights and responsibilities tells the customer that about payment agreements, but this notice does not replace the requirement of the utility to offer a payment agreement. Utilities should make sure to provide current copies of the rights and responsibilities. So it is your responsibility to replace outdated versions, and those versions, those new versions, are available on the IUC's website under customer assistance.
The chart in front of you highlights the minimum rule requirements for offering a payment agreement under Iowa Administrative Rules for a customer who has a delinquent balance. The utility is required to offer at least a 12-month term with no down payment required. We call this a first payment agreement. The utility is also required to offer a 4-day grace period for one late payment on that first agreement. If the customer makes 2 consecutive payments on that first agreement, the utility is required to offer a second payment agreement. That agreement has to be at least the same length as the first agreement or longer, but the utility can require 1 month as down payment. If the customer does not make 2 consecutive payment agreements or they break that second agreement, they can be disconnected with 24 hours notice. Some additional reminders on payment agreements is that the utility can offer a custom agreement. We have many utilities that will let customers choose their own terms initially, but just keep in mind that prior to disconnection, there has to be at least a 12-month agreement offered, and a second if the customer makes 2 consecutive payment agreements. I also wanted to remind those listening that there is a reasonableness standard in the rules, which requires utilities to consider any changes to a household situation, such as income, ability to pay, and special circumstances. The customer is allowed to make a request for additional terms in their payment agreement based on documented hardships. When talking about landlord-tenant rules and guidelines, the Iowa Utilities Commission rules are largely silent on specific scenarios. So I do want to encourage those listening to consult your local legal counsel or call the Iowa Utilities Commission staff if you have a unique scenario. But the next two slides offer some reminders on things to consider when looking at landlord-tenant agreements. We encourage landlord-tenant agreements because they are designed to protect the utility, the landlord, and the tenant. And they have established rules for when the service is switched or when a situation occurs where there is a delinquent balance that can protect the property and streamline the process. Also, as a reminder, the utility cannot put the bill into the tenant's name without the tenant initiating requests to start service, and that the utility should offer service to a resident where the landlord wants to stop service in the landlord's name. We also wanted to remind participants that the landlord cannot use disconnection as a means of eviction or charge a tenant more for services than what the landlord is billed by their utility company. However, a landlord may charge utilities as an undisclosed portion of the rent, and the customer must work with their landlord if the landlord is the customer of record. Moving on to medical stays. A utility is required to offer a medical stay for a customer who has exhausted all options. We encourage a utility to offer a payment agreement prior to going down the medical stay route. A medical stay is for 30 days. A customer must request a medical stay and have a medical professional provide documentation in writing to determine if to validate that medical stay. The utility determines if the medical stay is approved. And we definitely encourage utilities to document all medical conditions at the time of application. If a household situation were to change and a new medical stay was documented, a utility would have to offer an additional medical stay. We typically say that a utility just has to offer one medical stay per delinquent balance. So once the balance is paid off, then another medical stay could be requested. There is no timeline in the rules for when medical stays have to be offered. Next, I'm going to turn it over to Keita to talk about LIHEAP.
The Low-Income Home Energy Assistance Program, or LIHEAP, is a federally funded program designed to help qualified low-income families in Iowa by providing a one-time payment to their heating utility. The LIHEAP program is administered by the Iowa Department of Health and Human Services under the direction of Bill Marquez, Program Manager. Eligibility letters for those participating the previous year went out in August, and that alerts those who qualify that they can submit a new application on October 1st. This pertains to the elderly and disabled customers. New customers that'll be submitting applications on November 1st and thereafter, with their last day to apply is April 30th, 2026. Individuals qualifying for LIHEAP cannot be disconnected during moratorium, which is November 1st to April 1st. And I'll just mention again, back to that delinquent, that during that moratorium, the 24-hour or that door posting in person has to happen. Important tip to remember that leading up to November 1st, the law does not prevent a customer from being disconnected if they have applied. After November 1st, customers are allowed 30 days to apply for LIHEAP to avoid disconnection. One more piece that happens usually during about the time of moratorium is the weather rule. This rule specifically applies to electricity used as the only source of space heating and prevents disconnection when the temperature is at or below 20 degrees. But the utility can then proceed with disconnection once the temperature rises above 20 degrees for at least 24 hours. Oops. Let's talk about how the IUC conducts its complaint evaluations. Customers from utilities across the state submit complaints to us. All utility bills in Iowa have the IUC's contact information listed as a resource for customers who are unable to resolve their complaint. This does cause some confusion for customers. IUC gets calls in which customers have questions about billing and payments, and the staff here either transfers to the utility or provides the phone number to the customer. Escalated complaints come in the form of phone calls, emails, through our website, or paper mail. Once received, staff confirms the customer has taken their complaint to the utility. If the customer has taken those steps, a review of applicable authority takes place. Sometimes this requires assistance from regulatory law. Sometimes the discussion happens with the customer during the first interaction. And then often external referrals will happen. So those referrals will go to other agencies, state and federal, like as the LIHEAP program, HHS, may go back to the utility, such as the case of a municipal water, or the local governing body if necessary. Municipals and RECs have their own local governing bodies. Often we'll make referrals to a community action agency or to 211 for assistance with utility bills. And as Stephen mentioned, we'll suggest folks call 811 so they can call before they dig. If that jurisdictional review decides we find that our rules are applicable, often we'll make a pre-call to the utility before we initiate an investigation, such as a municipal and REC who we don't talk to very often. We'll give a call, walk through the complaint process, and all of our inquiries, whether they come in by phone or in writing, are mostly conducted via email. So we'll talk a little bit about those inquiries. There's general inquiries and more are informal complaints. So general inquiries are typically a quick turnaround, such as disconnections. Sometimes a general inquiry may require a little more time, and so we'll give the utility a little more time if it's a little more complex. It essentially is facilitating a response for the customer from the utility. Our informal complaint investigation, the process is largely spelled out in the rules, and the staff will send out initial letters to the customer and the utility. So the customer, the utility, and the Office of Consumer Advocate, OCA, is copied on all of the correspondence for those investigations. And I should mention that the other inquiries we do, OCA is also copied. We give the utility a number of days to respond and then review the complaint, the response, and the rules, and issue a proposed resolution. The rules also offer the opportunity for a formal complaint, and that happens when in the 14-day period after a proposed resolution is issued. It can be requested from the customer or the utility or OCA. We'll talk a little bit about telecommunications and those complaints. As Stephen mentioned, telecom, which in our case is landline telephone, is largely deregulated. We do still retain the authority to hear complaints, and some examples of those complaints might be a slamming and cramming, or where the customer has been switched to a different provider without their permission. We do get customers calling about unburied lines and damaged pedestals. And so often we'll do a referral or reach out to the utilities in the area just to assist the customer in figuring out whose lines are laying on the ground or who needs to address the issue. This helps the IUC and the utility make sure that everyone's safe. We take complaints about the alternative operator services, and those are related to calls made from incarcerated persons. There are a couple of other telecom programs that are focused on from the IUC. The Federal Lifeline program in Iowa, there is information on our website, and we do speak to folks about this. The best place for information for a customer or a utility provider is lifelinesupport.org. And the IUC has staff that manages the dual party relay services.
And to wrap things up, I'd like to discuss some of the news and updates for the year. I wanted to highlight recent leadership changes here at the Commission. Chair Sarah Martz was appointed as Commission Chair May of 2025. We also have a new General Counsel, Ralph Morosco, and Chief Operating Officer, Nicole Tumeyer. With some of those changes, we're offering additional transparency to customers and stakeholders here at the Commission. So we have brought back our monthly commission meetings. Those are open to the public and on our hearing and meeting calendar. Additionally, we have completed all our required administrative rules updates. This was an initiative from the governor's realignment a couple years ago. So we are currently in a rules moratorium, but plan to open rulemakings back up for consideration January 2026. All rulemakings go through our electronic filing system. You can find a link on our website, efs.iowa.gov. This legislative session, the governor's energy bill did not pass, but we're anticipating changes for next session. We're also keeping an eye on customer service on legislation around community solar, as we have seen a trend where states have become to consider using LIHEAP to be a source of funding to pay for community solar subscriptions. And so this would change the ownership of community solar from utility to developer. And here at the Commission, we're continuing to track federal regional issues as well as the ever-changing energy landscape. And so to wrap things up, we want to thank you for listening to our presentation today. If you have any questions, you can email customer@iuc.iowa.gov. This email is designed for complaints, inquiries of the Commission, or if you'd like to reach me directly, my personal email is listed. Thank you again for your time.